Welcome back. Thanks for staying with us. The Employment Equity Act was signed into law back in April. It allowed for the Labour Minister to set specific racial targets for 18 sectors across 4 different skill levels. This was disputed by trade union Solidarity, who took the department to the CCMA. It reached an settlement agreement with government, which some legal quarters have said would be a welcome development for many businesses across the country. Let's unpack this further with Adil Patel, the National Practice Head of Employment Law at Cliffe Dekker Hofmeyr. Very good evening to you. Thank you so much for your time. The Employment Equity Act has been regarded as a big boost for business. In what ways?
Thank you. I think that we need to first place things into context. The Employment Equity Act came into being in 1998 to address the discriminatory practices from an employment perspective that many South Africans faced during the dark days of apartheid. The Employment Equity Amendment Act was then passed, but not yet implemented because it was not yet confirmed by our President. So as of today, it has not yet been passed into law. But prior to it being signed by the Department of Labour, Solidarity lodged a dispute with the International Labour Organization against our government in relation to the Employment Equity Amendment Act. The International Labour Organization then requested, which is kudos to our institutions, requested the Commission for Conciliation, Mediation and Arbitration to facilitate or mediate the dispute between Solidarity and our government. Despite it lodging a claim to the International Labour Organization, Solidarity also lodged a dispute against government at the Labour Court in relation to the Employment Equity Amendment Act. Under the auspices of the CCMA, Solidarity and government then had concluded a settlement agreement regarding Solidarity's dispute. Now, what was Solidarity's complaint? Solidarity's complaint was, in essence, that the Employment Equity Amendment Act was an inhibitor to employment and to growth in this country because it placed too much emphasis on race as a criteria for employment in South Africa. Under the settlement agreement, the parties will make that an order of court pursuant to Solidarity's claim at the Labour Court, and government will pass regulations. At the moment, we're waiting for guidance from government. There have been much commentary regarding the impact of the settlement agreement on the Act. Some quarters have indicated that the settlement agreement is nothing but a regurgitation of what has been enumerated in the Employment Equity Amendment Act, while others have hailed it as a victory for whatever purpose. But for our listeners, the most important amendment to the Employment Equity Amendment Act, which has not been amended by the settlement agreement, is the following. Prior to the Amendment Act, employment equity plans as how you were going to achieve racial equality at the workplace was the prerogative of employers. Under the Employment Equity Amendment Act, that prerogative, that power has been removed from employers and now is in the hands of government. So government will set the targets, and you as the employer need to comply unless you have justifiable reasons, either in terms of the act or in terms of the settlement agreement. So if one takes away all the noise around the settlement agreement and the Amendment Act, the most fundamental change which the settlement agreement concluded under the auspices of the CCMA pursuant to a dispute lodged with the International Labour Organization, is that government now has the power to set the targets which employers must comply with in order to achieve racial equality and gender equality within the South African workplace.
So on that note, if you'll allow me the interruption, pardon me, what criteria will businesses have to take into account when drafting employment equity plans? So,
ma'am, what it's going to need to do is it would need to look at the targets set by government, and currently you would know that government has set out for 18 sectors, has published targets for people to comment on. When taking that into account, you would need to determine whether you fall within a particular province or will you apply the national targets. Government has taken into account the national active economic population when setting its targets. Those targets may potentially change given the consultation process that government is currently or is embarking upon at the moment, and it may have changed as well because of the settlement agreement. But the right to set those targets, what factors government takes into account, national active economic population, the sectors, input from various sectors, that power now rests with government. You as the employer must lay out in your employment equity plan how you're going to achieve the targets set by government, whereas before you had the option or you had the power to determine what were those targets depending upon the national active economic population or regional, and you could then set the targets. That power has been gone. That power is now gone. And understandably so, because if one looks at the most recent report from the Commission, it says that after so many years of democracy, we have at the top echelons of our workplaces not achieved equitable representation, and that is the reason the power has been one of the reasons the power has been removed from employers and placed in the hands of government as such. Will there be litigation that will ensue as a result of the targets? I have no doubt about it. Will there be litigation that will ensue as a result of the Act? Most certainly. Will there be litigation that will ensue as a result of government indicating that the reasons employers provide for not complying with the targets set by government? Most certainly.
Very well. Thank you so much for your time and giving us such a clear background. Adil Patel, National Practice Head of Employment Law at Cliffe Dekker Hofmeyr.